Friends, at the outset, let me thank the charioteer of this program, Major General Neelendra Kumar. He has given me a wonderful topic, teaching constitutional law. How difficult it would be, you know. Let us probe and discuss this particular problem. I also take this opportunity to salute our teaching community who are responsible for imparting and promoting legal education through normal as well as in difficult times through their synchronous and asynchronous teaching, learning techniques. Friends, when we talk about teaching, we think about teacher-taught relationship. India has the richest culture of respecting the teacher. Guru is considered to be the personification of knowledge. Kevalam Jnanamurtim we say. And in our prayer about Guru also we call him as Parabrahma. Not only that, even God incarnate had to have a Guru. Whether it is Ram or Sri Krishna, whatever it may be. And you know that Sri Ram, who lived like a human being, was tutored by Vasishtha, and his personality development occurred when he is associated with Vishwamitra. So that is a wonderful culture we had. And then even in the prayer, we do not specify particular God. Both the teacher and the taught, they pray the God that they are partners of learning, not rather having any undue influence, teacher or taught. They are partners of learning, my friends. A teacher affects in eternity, and no one can tell where this influence ends. These were the words of Henry Adams in 19th century. He was an American historian, journalist, and an academic. Teachers, more than any other class, are the guardians of civilization. That is another one. The destiny of any nation, my friends, is shaped in the classrooms. These were the words in Kothari Commission report. I must tell you, whether it is good or bad, the influence of the teacher will be there. The seeds of the Second World War were sown in the classrooms of Germany by the teachers who were admirers of Adolf Hitler. So that much influence they can play. That is why even in the new education policy, teachers truly shape the future of our children, they said. And therefore, they are the future of the nation. That much importance is given to the teachers. Teacher must be a committed man, committed to the future of a man, to future of the humanity. These were the words of Sarvepalli Radhakrishnan, my dear friends. For that, to have that role, prominent role, the teacher must always be like a student in preparing, developing, and expanding his frontiers of knowledge. That is why it is stated he must always be a lighted candle in himself. If he is not a lighted candle in himself, he will never be able to lit up the flame in others. Credo of every law teacher, more so with regard to constitutional law teacher, is that always he must update, upgrade, and enrich his knowledge. And then you must also remember what was stated by William Arthur Ward. He stated that a mediocre teacher tells, like an information provider. A good teacher explains, the superior teacher demonstrates, and the great teacher inspires. Now you can estimate for yourself in which category you are in. The simple formula, my dear friends, is that in every classroom setup, what is the entry behavior of the students? What is the level of their learning? After the class is over, what is the terminal behavior? Their level of learning. Terminal behavior minus entry behavior is the benefit accrued. If the benefit accrued is significant, you are a good teacher. You may be an inspiring teacher. If the benefit accrued is 0, you are not fit to be a teacher, my friends. And then one should understand teaching is a purposive, inspiring, interpersonal activity of learning between the teacher and the taught. And then teacher is not merely the facilitator of learning. He is a diagnostician of learners' needs, a motivating force, not merely an attention seeker. He is also an analyzing factor of the behavioral patterns of the students. Another thing is that he is a good evaluator. Good teaching, like writing, good writing, is rooted in careful selection. A teacher must know not only what to teach, but also what not to teach. That is another angle which you should remember. There is a formula, NH, need for achievement formula. That is, in every classroom, whatever may be the class you are addressing, there will be 3 types of people. Students. Number 1, some group of students, they are mastery oriented. There is no problem with regard to them. They will not leave you unless they get themselves clarified about the concepts, about the provisions, about the case law. They are mastery oriented students. The second type of students are failure avoiding students. They are not that sincere in the class, but somehow or other they prepare for the examinations, and what they want is that they should not be a failure student. Another type of students are failure accepting students. This is a very dangerous group of students. They may infest failure avoiding students, they may infest even mastery oriented students. So what is required is that the role of the teacher is to see that the failure accepting students become failure avoiding students, and failure avoiding students become mastery oriented students. This is the task of every teacher, whatever may be the subject. Now coming to constitutional law. Not all will get an opportunity to teach constitutional law, my friends. There are 2 irreducible minimum subjects. Number 1, jurisprudence. Number 2, constitutional law. Whatever may be your discipline, whatever may be the subject you are teaching, you must have basic knowledge of these 2. Indian constitutional law is a live wire, my friends. It has a life of more than 72 years by now. It has faced many challenges. It has seen the attempts of subversion. It has seen the phases of post-constitutional developments, both with regard to interpretation, both with regard to adoption by the governments. It has facilitated the mixed economy in the beginning. socialist economy in the middle. Now it is also facilitating globalization, my friends. It is a wonderful document, but one should think very carefully. The constitution which we have adopted in the year 1950, adopted in the year 1949, 26 November, came into force on 26 January 1950. That was rather developed by metes and bounds. There were nearly 105 amendments, my friends, at the rate of 1.5 amendment per year. And then you look into judicial interpretation, starting from A.K. Gopalan to Maneka Gandhi and afterwards, starting from Shankari Prasad Singh case to Keshavananda Bharati and afterwards. How many changes occurred? Do you think that the same constitution we have? They have rather, in judicial interpretation, changes took place in the interpretation of contextual and consequential, literal to pragmatism, and then we also hear about judicial activism, judicial dynamism, judicial overreach also. But what you should understand, all these things come with reference to constitutional law only. Every part of the constitution is subject to varied interpretations. Whether it is basic structure theory, as you have noted in Keshavananda Bharati versus State of Kerala, AR 1973 Supreme Court page number 1461, or you go to from A.K. Gopalan of 50s to Maneka Gandhi versus Union of India, AR 1978 Supreme Court page number 597. What has happened? And then they have also laid down golden triangle 14, 19 and 21. We heard about transformative constitutionalism. And in recent times, this controversy relating to constitutional morality, which they have interpreted into the various provisions. One thing you should remember, Granville Austin long back has stated that the Constitution is first and foremost a social document. Of course, these provisions of Part 3 and Part 4, they were incorporated in the Constitution with a view and expectation that one day the tree of true liberty would bloom in India. One has to rather remember his statement. Constitution is different from other subjects in terms of statutory treatment or cases. The reason is that constitutional law is a fundamental law of the country. All the other laws, rules, regulations, bylaws, notifications or ordinances or even custom or usage shall work under the Constitution, not above the Constitution. That is the reason why it requires a different treatment in teaching. Further, I should tell you that you will have to face different set of students. LLB students, LLM students. Sometimes you are required to give training to public officials. So different type of treatment is required, my friends. There are, according to me, you may add one or two more, but irreducible minimum number of steps are there. There are 10 commandments, 10 steps for a successful teaching of the constitutional law. Decide, number 1, whether it is a learner-centric or curriculum-centric approach that you will have to adopt in your institutional setup. Number 2, evolve suitable strategy and method of teaching. Number 3, set objectives of teaching. Number 4, evolve and evaluate the course content. That is another angle. Assess the challenges one may face in dealing with the Constitution. That is very, very important, 5th point. And then, based upon these all points, 5 points, the 6th one is that identify appropriate method of teaching. And nowadays, especially you have seen synchronous learning. So you must be well aware of how to integrate ICT with your teaching. Then review whether I am correct or not. Decide on evaluation methods. Prepare a blueprint for your teaching, an instructional plan for your teaching. These are the 10 irreducible minimum number of things one has to observe if he wants to be a successful teacher of constitutional law. Step 1, what we have discussed. Decide whether it is a learner-centric or curriculum-centric approach one has to adopt. In learner-centric approach, teacher is the facilitator. Okay. In most of the national law schools, where the teachers have autonomy, they adopt this method. And then people say that Socratic method will be highly useful in this aspect. But choosing the method of teaching is your prerogative, my friends. So classical Socratic method is not there even in United States. They have coupled it with case study method. And then the second aspect is curriculum based. In a semester or in an academic year, you are supposed to cover this syllabus. So your teaching is rather confined to these areas, and sometimes it would be a ritualistic teaching to cover the syllabus, not to uncover the syllabus, as in the case of learner-centric teaching. And then we can also see as teachers, some teachers see teacher-centric. Whatever teacher says, that we should accept. So first of all, the first step is to decide whether you are going to have learner-centric or curriculum-centric or teacher-centric approach. Second method, evolve the strategy. Deliberately, I am using the word strategy, not the word method. Strategy is the method that you opt for to realize the goals of your teaching. When we are to achieve any objective by using any particular method, it becomes a strategy. You may opt for different or various kinds of methods. And then goal. You must keep in mind when you are opting for a strategy, what is the goal? Is it merely black letter law that you are going to teach, or experiential teaching that you are going to adopt? And then strategies may change. Not a single track you observe every time. You may change the strategies as well. And then in adopting this strategy, underlying you have tactics. Teaching teaching tactics is the behavior of the teacher which he manifests in the classroom. Teacher, by his actioneering, by his talking, he adopts specific tactics. That is individualistic, my friends, I will tell you later. It varies from teacher to teacher. Teaching is an act of will. It is an art, no doubt. But it is an act of will, notwithstanding any amount of specialization, any amount of freedom that is given. Each teacher will have his own way of teaching. Now, look back, my dear friends. As teachers, when you look back to your teachers, some teachers adopt the method of like giving grapes, wherein no further effort is required. You will be just repeating whatever teacher says, you will get first class marks. It is like grapes eating. Some teachers, they will test you, but they are also very liberal in teaching. It is like peeling the banana. Eating banana is very easy, but you will have to peel it. And another type of teachers would be there. It is like coconut. Unless you break it, you will not get the content. So, that you will have to decide which type of teacher you wanted to be, or which type of teachers you have admired previously. And then go for step number 3. What is that? Set objectives for teaching constitutional law. Minimum objectives in teaching the constitutional law, my friends, is that often we ignore. That is why some teachers will not become successful teachers in constitutional law. Let the student understand and identify what are the goals and values of the Constitution. Do they know what is a value? Do they know what is a goal? And then what is an instrumental value? What is a goal value? If you take your preamble, you will know that sovereign, socialist, secular, democratic republic, they are adopted in order to achieve justice, liberty, equality, fraternity, assuring the dignity of the individual, and unity and integrity of the nation. My dear friends, you should also explain in the beginning itself, what is Constitution? What is constitutional law? What is constitutionalism? And then you may also refer to the decisions that are latest, that is Joseph Shine case or Navate Singh's case, all these things. So that is an important aspect. Then you should give the constitutional background. Framing the Constitution has occurred under certain specified circumstances. I will give you an example, my friends. Every nation has the Constitution. Every nation has in its Constitution the provision relating to equality. The provision relating to equality. One provision will be there. The 14th Amendment to the American Constitution. The second principle of rule of law of A.V. Dicey of 1885. But no further provision was there. Under the Indian Constitution, you have the provisions relating to specific discrimination. Under Article 15, religion, race, caste, sex, place of birth, or any of them. And with regard to equality of opportunity, specifically they have specified 2 more grounds. And we have seen Article 17, untouchability is abolished, and the practice of untouchability is to be punished in accordance with the law. Abolition of titles you could see under Article 18. Why so many provisions, so many provisions are brought under equality. The background has to be seen. Not only that, you go to Article 19, why so many restrictions were made. Under Article 21, why they have adopted procedure established by law. The students are supposed to know. The Constitution was framed in the midst of pangs of partition. Fundamental rights were framed over the violation of fundamental wrongs. That is why more restrictions were there at that time. That one has to explain why we have brought in preventive detention, even during peacetime, constitutionally guaranteed. Why it has happened like that? Let the students have grasp over black letter provisions, that is the first one. And then go for analysis. How to apply these provisions to the new patterns, new fads, and how to go about it. For that, experiential learning is required. That is how mock trial and moot courts are adopted with regard to the Constitution. How seemingly minor changes in facts give different definitions. Students are often confused with regard to this. I will give you one example. State of West Bengal versus Anwar Ali Sarkar. The same judges have decided Khati Rani Rawat versus state. Similar set of facts, but the difference is preamble. So different decision has come. As against the company, how the Supreme Court has taken cognizance of the case under Article 32, MC Mehta versus Union of India, Sriram Fertilizers case. How different opinions were given in Northern Caterers case and Maganlal's cases and Vajravelu Mudaliyar's case. This is irreducible minimum, my dear friends, you will have to think. And then tell the students about the judicial craftsmanship. How the things have developed. On the same provision, how the things were developed. A.K. Gopalan to Maneka Gandhi. And afterwards, Lieutenant Colonel Natasha in 2021 case. And the major thing is that you must make the students aware of the procedural settings and the various subjects. Okay? We cannot avoid any subject. All are related to the Constitution, whether it is politics, whether it is history, whether it is economics, any subject including medicine. So, one has to focus on those things with gumption in order to explain it to the students. I will give you one example. Samshayar Singh case is there. Whether ours is a parliamentary system or presidential system or classical presidential or a marked different from those things. These were discussed at length in that case, but my dear friends, it is basically a political science problem. You think about taxation, GST, problems of economics. You think about gender perspective. Recently, we have seen Babita Punia and Lieutenant Colonel Natasha's case. Permanent commission for women in army was given. And then international law automatically will not become part of Indian law unless a law is made by the Parliament under Article 253. CEDA, human rights, refugees problems, and CAA, all these things. And then one has to mention about plurality of opinions. Plurality of opinions. That means you have unanimous opinions of the court, concurring judgments, and then dissenting opinions. Yesterday's dissents have become majority judgments subsequently. So unless you explain this plurality of judgments, the students will not be clear, my friends. And then recent constitutional developments, one should not forget. That is why I said he must update, upgrade, and enrich his knowledge all the cases in recent times, they have set very good principles in the development of constitutional law. Of course, some judgments are presided over by 2 judges only, not 5 judges as required under Article 145, Clause 3.